Hello there, everyone. I'm attorney Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. So please like and subscribe our page below. Hit the notification button so you can be alerted as new videos drop. Today, I want to talk to you about whom should I tell about my estate plan. Now, creating an estate plan is typically a private matter, not something you share in detail with everyone in your life. After all, what you choose to do with your money and property is your business. Your partner might not know what is in your plan, especially if you created it together. But beyond that, does anyone else really need to know? The short answer is yes. There are good reasons for keeping certain aspects of your estate plan to yourself. However, if you keep too many details to yourself or forget to keep others in the loop, your well thought out plan may not work the way that you had intended. An estate plan cannot work if it's invisible. If no one knows that your plan exists, or if no one can access your documents, it may as well not even exist. Verbal promises carry no weight. Simply telling someone about your goals and wishes is not enough. Your wishes must be properly documented. You may want a tiered approach to divulging your plans. Now, keeping an estate plan private makes sense to an extent. That's why people often use trust-based plan instead of a will-based plan. The latter is subject to the public probate process, and almost anyone can obtain court records of that process and learn details about you, your family, and what you owned at your death. Within your family, you may keep your estate plan private to avoid drama and hurt feelings over who will play a role in your plan and who will receive your money and property at your death. Or you may worry that if word gets out about your plan, others' opinions will sway your decisions. You may instead prefer to make rational, unemotional choices, removed from the competing voices of friends and family who stand to inherit. While you absolutely have the right to keep your estate plan private, doing so is not always in your best interest. The real question then becomes, how do you share something so personal without feeling like you are broadcasting it to the world? The trick is knowing whom to tell what, when to tell them, why to tell them, and how to tell them. Telling someone can mean different things, from giving them copies of all of your plan documents and keys to your digital wallet, to letting them know that they are named in the plan and whom to contact later for more details. You might also use a tiered communication approach that aims to put the right information in the right hands at the right time to prevent confusion, avoid family disputes, and create as little stress as possible for your trusted decision makers and beneficiaries. So let's talk about who's on this tier 1 and who you might want to disclose information to. The people you have legally appointed to act on your behalf, including your spouse or significant other, especially if you did the plan together, or if you share joint accounts or property, or perhaps you live in a community property estate, or if you've appointed them to one of the roles in your estate plan, then they may need to act quickly or coordinate with other decision makers. You probably want to share this with your personal representative or executor, and that's the person who you've appointed or named in your will to oversee the probate process if one is needed. You also want to share your information with your trustee or a successor trustee. And this is just who manages accounts and property that were or will be funded into the trust according to your trust agreement. You also want to disclose to an agent under a financial power of attorney, and that's who handles your finances, either immediately or in some cases only if you're unable to manage them. You also want to share your information for your agent under a medical power of attorney, and that's where you've named somebody to make healthcare decisions for you if you cannot make them or communicate your wishes for yourself. You also want to share information with the person that you've named as a guardian for any minor children that you may have. So let's talk about what you might want to share. You definitely want to share enough information so these people can act immediately and effectively. So you want to share the location of your completed estate planning documents, whether it's wills, trusts, powers of attorney, healthcare directives, including where originals are kept and where copies or electronic versions can be found. Information on how to access these documents if the originals are stored somewhere, such as in a safe deposit box or a home safe. You also want to provide a list of everything you own, including financial accounts, real estate, business interests, and digital assets. Also provide instructions for special property, whether it's businesses or firearms or intellectual property, and even those pets. You also want to disclose digital storage location and credentials. So there should be a secure cloud vault, an encrypted drive. You want to share this information for any digital assets that you have, as well as emails, business documents, electronic accounts. You also want to share your contact information for your estate planning attorney. Share your wishes and goals, including the choices that you've made in your plan and how you want your decision makers to carry out their responsibilities once they step into these roles. You may decide that the agents named in your medical power of attorney are less likely to need detailed financial information. However, they still should know where to access your estate planning documents. And you want to share this information as soon as possible after you've appointed someone to this role. Anytime you appoint a new decision maker or change the order in which you have appointed them to serve. You also want to share whenever you move your estate planning documents to store them in a new location periodically to confirm that they're still willing to and able to serve. So you want to talk to the people in those roles periodically. The reason why you want to share this information with your loved ones and close family is that they can't do their job if they don't know that they've been appointed and how to access what they actually need. Delays in knowing or confusion about who is in charge and where your documents are located can cost money, result in unintended property damage, or cause unnecessary family stress and conflict. So the best way to share this information is to meet in person or via video to explain their role and your goals and desires. You also want to provide a written roadmap with tasks that they will need to perform, a list of everything you own, and key contacts, for example, your financial advisor, attorney, accountant, and insurance agent. You also want to store digital copies securely and share controlled access with relevant decision makers and confirm that they accept the role and understand the responsibilities. So let's talk about tier 2. And these are the people that you want to provide selective access and strategically share information. And these would be the individuals or entities that you've chosen to inherit from you upon your passing, even if you've not appointed them to any decision-making roles, such as a spouse or significant other, your children, your grandchildren, or other relatives, friends, or non-relatives, and maybe perhaps some charities or nonprofits or religious or educational institutions. You may also choose to share your plans with loved ones who might expect an inheritance, especially if you intend to leave them out. You want to provide for them in other ways, for example, as a direct beneficiary of something, or by providing funds to them during your lifetime, or give them less than others in similar relation to you. While the conversation may feel uncomfortable, addressing it now can prevent painful surprises later and ease the burden on your decision makers and loved ones who would otherwise be left without your explanation. And what do you share? You want to share the nature of the gift, money, real estate, investments, whether it's personal property, and share any obligations attached to that inherited item, whether it's taxes or upkeep, or just management, or perhaps there's legal restrictions, just so they're aware of their right to refuse the gift, with caution that the disclaimer must be made before they actually take ownership or control of the item that is being left to them. And you want to share this information with your beneficiary sooner rather than later, especially if the gift is complex or burdensome or potentially unwanted. That way you can provide more flexibility and timing if the gift is straightforward and unlikely to cause issues. But do not wait until it's too late to actually have these conversations. And there's some really key benefits to sharing this information. First is that it prevents surprises that can cause stress or resentment amongst family members. It also allows time for the beneficiary to prepare for the upkeep, sale, or management of whatever it is that you're leaving them. It also gives you a chance to reallocate gifts that might otherwise be refused by that beneficiary. You want to communicate with these beneficiaries in person, by phone, or in writing, and explain expectations or conditions attached to the gift. For sensitive gifts, whether there's a disinheritance, an unequal shares, some heirlooms, or pets, or business interest, you want to consider having the conversation with your attorney present if you feel uncomfortable addressing it on your own, or if you want to create a record of the discussion to demonstrate your intent and legal capacity in the event your plan is contested in the future. By failing to plan and to clearly communicate your wishes, there can be some serious consequences for your estate. Let's talk about the potential of some issues that might come up. There could be a safe deposit lockout. The executor cannot find your original will and believes it may be in your safety deposit box at the bank, but their name's not on the count, forcing a court order to open it, so a probate. What about forgotten passwords? Digital estate planning documents are stored in the cloud, but the account credentials were never shared, leaving files permanently inaccessible. There's also the disappearing executor or successor trustee. Maybe you've named executor or successor trustee has moved away years ago. Maybe they changed phone numbers and they cannot be reached when needed, and you did not appoint a backup. Or maybe there's an unwanted gift. You leave your classic car to a loved one who you know will treasure it as you did. However, they do not have the space or the resources to maintain it and reluctantly refuse the gift. If you did not name a backup beneficiary, the car passes to your residuary beneficiaries who may not value or appreciate it. And then there could be the long lost co-owner. If a vacation home left to a nephew is actually co-owned with a distant cousin, your nephew is forced into a joint ownership agreement that leads to years of awkward and expensive disputes. And then there's the final will problem. Multiple unsigned drafts are found on the decedent's desk with no clear final vision. Your loved ones are left to argue amongst themselves and in court over what your true intention was. Your death is more than an administrative process, but thinking about your estate plan in that way can inform practical choices that make wrapping up your estate smoother for everyone involved. An estate plan works best when paired with a communication plan that shares the right amount of information with the right people at the appropriate time, balancing privacy with transparency and flexibility. If you're unsure how to strike that balance, then you want to call your qualified estate planning attorney that practices in the state in which you reside and discuss your plan with them and devise the best strategy for informing your loved ones. I want to thank you all for watching. I'm Kelly Longtin from Kelly Longtin Law. Please like and subscribe our page below so you can stay in the know about all things estate planning.